The Delhi High Court delivered a judgment of extreme importance that's being hailed as a victory for the rights of taxpayers and the fairness of procedure. In this particular case, the court has put a check on the powers of tax authorities, particularly when it comes to the issuance of show cause notices for GST registration cancellation. In this particular case, the petitioner here received show cause notice dated July 2, 2024 from the proper officer, herein the respondent. The notice, which we will be referring here to as the impugned show cause notice, it was called upon Mr. Petitioner to show cause as to why his GST registration should not be cancelled. Crucially, the only reason provided in the impugned show cause notice for proposing to cancel Mr. Petitioner's GST registration was the reproduction of Rule 21B of the CGST rules. The notice stated that Rule 21B person issues invoices or bill without the supply of goods or service or both in violation of the provisions of the GST Act or rules made thereunder. Mr. Petitioner here Mr. Petitioner here directed to file a reply to this notice within 7 working days and to appear before the proper officer on July 10, 2024. Additionally, this is very important to note that Mr. Petitioner's GST registration was suspended with immediate effect from the date of July 2, 2024, which was the date of the show cause notice, the impugned show cause notice. On July 9, 2024, Mr. Petitioner submitted a reply to the impugned show cause notice. In his reply, he raised two key points. First point was that he argued that notice was cryptic in nature and failed to mention the specific allegations regarding which bill or invoice was issued without the supply of goods or services. He also objected to the impugned show cause notice on the ground that it did not mention any name or designation of the issuing officer. Right. 1 month after 1 month after submitting the reply, no decision was made on the on that particular show cause notice. Meanwhile, the petitioner's GST registration remained suspended. Aggrieved by this all situation here, the petitioner filed a writ petition in the Delhi High Court challenging the validity of the impugned show cause notice and the continued suspension of his GST registration. So, sir, what was the central issue in this situation? The central issue in the situation was that the court had to address a crucial point, a crucial question: is the show cause notice for cancellation of GST registration valid if it fails to provide specific reasons or allegations? The court in this particular situation made several important observations. The first observation which the court made was the court noted that the impugned show cause notice did not provide any specific reason for proposing to cancel Mr. Petitioner's GST registration. It merely reproduced Rule number 21B of the CGST rules. The court emphasized that the impugned show cause notice failed to indicate which transaction was alleged to be in non-compliance with the statutory provisions. Right. The court explained that while the Rule 21B of CGST rules does not provide for cancellation of GST registration, if a taxpayer issues an invoice or bill without the supply of goods or service, the proper officer here failed to specify which invoice, which bill failed to specify which invoice failed to specify without the corresponding supply. Right. Right. In this particular crucial observation, the court stated that the purpose of issuing show cause notice is to enable the noticee to respond to the allegations on the basis of which an adverse action is proposed. Without the specific allegation, how can the person reply? That makes the show cause notice renders meaningless. Based on this observation, the court reached to the following conclusions. What was the conclusion here? The first conclusion was that the court observed that the impugned show cause notice failed to provide the specific reasons, right, for proposing to cancel the petitioner's GST registration. It merely represented the Rule 21B of the GST rules without indicating which transaction was alleged to be in non-compliance with the statutory provisions. The court here held that although Rule 21B provides for cancellation of GST registration, if a taxpayer issues invoice or bill without the supply of goods or services, the proper officer here failed to specify which invoice, which bill was allegedly issued without the corresponding supply. The court here opined that the purpose of issuing show cause notice is to enable the noticee to respond the allegations, right? Without specific allegation, the notice will be meaningless. The court here held that the impugned show cause notice failed to meet the requisite standards of show cause notice and therefore was liable to be set aside. In the light of these observations, the court allowed this present petition of the petitioner, and the court set aside the impugned show cause notice. The court directed that the GST registration here of the petitioner should be unsuspended, right? And the suspension order should be discontinued, right? The court, however, clarified that this order would not preclude the proper officer from initiating any fresh proceeding. He can issue the fresh proceeding, but with proper standards of show cause notice. This clarification ensures that the tax authorities retain the right to take appropriate action if they have a valid ground for cancellation of the petitioner's GST registration, right? So, what are the implications of this judgment? This particular ruling has several significant implications for the GST administration. What are these implications? First of all, this particular case sets a precedent that the show cause notice for the GST registration cancellation must be specific and detailed, not merely quoting the relevant rule. It becomes so vague that the petitioner cannot respond. This particular judgment provides protection to the taxpayers against arbitrary suspension of GST registration based on vague or non-specific show cause notices. This judgment puts the onus on tax authorities to conduct thorough investigation before issuing new show cause notices for GST registration cancellation. It also emphasizes that the importance of procedural fairness in tax administration, even in cases where there may be suspicion of wrongdoing. Right? You have to be fair. It may lead to reduction in the hasty and poor substantiated actions by tax authorities, potentially reducing the unnecessary litigation. This judgment was a very important judgment, right? I hope you have understood the judgment very well, and to get the link of this particular judgment or newsletter, you will find it on the screen and in the description box, right? So that was my time here. I'll see you in another judgment. Thank you.